Okay, welcome back, Attorney Steve. Part 2, software audit process. Is this just some scheme to collect and demand money from you, or is it a legitimate process initiated by the copyright holders? Let's go back to the Attorney Steve software audit whiteboard and let's see if we can find out a little bit more. So we're talking about handling your own audits. This is part 2. If you missed part 1, make sure you go back and find part 1. Very valuable, helpful tips you're not going to find anywhere else. Who's bringing it to you? Attorney Steve's bringing it to you. Been bringing it to you for years here. Okay. So more information real quick. You can find us at softwareauditlawyers.com. Tons and tons of information, videos, checklists, the things that you need to know. There's a very important checklist you should download off our website, Software Audit Lawyers, if your company's facing an audit. Okay. So we talked about the informants and piracy hotlines. We've talked about the regional law firms getting involved. We've talked about what to do. You get this demand letter and some of the different types of products you may be looking at. We've talked about some of the legitimate law firms that are not scams, so the public is aware that these are very important issues that you shouldn't just, crumple up and throw over your head. So let's go back to the board. So one of the things we say, if you're going to be trying to talk this yourself, you have to be careful. We have at this stage, and this is where we have your company, your officers, your directors, okay? These are people in charge. Now, in these software audit cases, you will often find some pushing and shoving by these copyright companies, these software publishers, and their counsel to hold the officer and director liable, okay? So now that's a big thing. So if you're an officer and director of a company, you could be actually held liable. They may want to try to come pierce the corporate veil. They may want to try to impose liability on your officers. They may say, how could you not know? You're sitting here, your company's got 20 copies of AutoCAD, you haven't paid for anything, and this is how you're running your business. Or we had one recently with Adobe. The attorney said they're using Adobe to create all their company graphics and business cards and web pages, and they're not paying for any of this. Like, really? So, like I said, but you have to be careful, because if you call up the person that's on your demand letter, okay, so you get the demand letter and you say, well, let's see, should I call this person? Okay, let me just work it out because I'm good. I've got a silver tongue. So you call them up and you say, we got the letter. We have some, we probably have about 10 copies of Windows and 12 copies of Office that we're not paying for. Cal license, what's a Cal license? Oh, I don't know what that is. Well, what company is this for? Because I have 3 companies. Okay, so you can see how you have now just created problems. The attorney's over there jotting down notes going, keep talking, keep talking. And so you're giving them the keys to the castle, they're writing it down, they're literally adding up what your infringement damages are going to be. So you're really shooting yourself in the foot by calling the representative. Okay, so that's usually where we say, call us, we'll get involved, we'll submit a representation letter, we'll try to get extended time to respond, let us take a look at it. Okay, so you have to be very careful, because they will be trying to get information out of you, and when you open your mouth, we've seen this plenty of times where you start now having them look at 2 companies, where before it was just one. Now you may have a sister company on the radar here. So, like I said, this is where, we offer low flat rate fees to make this a no-brainer for you, so that you can have representation, have us work the process for you. But nevertheless, beware. If you are handling your own audit, beware. Once you tell people things, they will use that against you in a court of law. If you're in federal court, let's say, they may put together a declaration. On this date, I spoke to this person. They told me they had 10 unlicensed copies. We believed them. Here we go. Now we're filing a lawsuit. They told us they had multiple locations and had not paid for software for either location. So you have to be very, very careful here in handling this yourself. Okay, so let's get back. So we have the demand letter. I have the question here, is this collections? Because some people are saying, like, maybe I have 1 copy or something and I'm just getting hammered. I'm getting hammered by this law firm, this IP firm from San Francisco, or what other state they may be from, Texas. we're getting hammered. So is this some sort of collection thing? And so, you know, we had one client ask us, can I, you know, I bought the software, I think it was a Rosetta Stone. Somebody say, I bought the software for my own personal use. Can I send an FDCPA debt validation letter? And I said, that's kind of interesting. You know, they are seeming to want to collect on a debt. That certainly seems the way they're acting. So there may be ways, and of course they don't want to tell you all their information, there may be a way to send an FDCPA letter if it's for family household purposes. So there's a lot of different things that you look at. You know, these are the types of questions that come up. Is this a collection activity or a valid copyright enforcement technique? Some people ask, is this a scam? Is this a scam? And again, I gave you some of the names of some of the legitimate firms in the field, some of the common firms that you'll see. So if you need more information, call us. We're happy to tell you if they're a legitimate firm that we've dealt with or not, okay? We talked about the FDCPA. Okay, so you move on. Let's just say you've got more time, you're able to, they said, fine, we'll give you another 30 days to audit, you know, fine. You haven't said anything, everything's been quiet. And so the next step usually is you want to get the confidentiality agreement. You want to make sure that nobody's going to be talking about this to the extent that it's protected by the Federal Rules of Evidence, what we call FRE, Federal Rules of Evidence 408, okay? So you're trying to get as much protection as you can possibly get. We have a sample on our website. If you go to softwareauditlawyers.com, we have a sample confidentiality agreement. Again, who's bringing you the goodies here? Attorney Steve. All right, so we're going to be wanting to do that. And again, it's crucial to get these confidentiality agreements because these software organizations, these are trade associations, these are not law enforcement, but they may want to put this on their website. And what they tell us is they sort of brag about it and go, you know, hey, it serves a pretty useful value for us to post a press release or post it on our website. You know, it's pretty big news for us. And sometimes they even tell us, do you want to buy confidentiality? Does your client want to buy it? I was like, buy it? So anyway, so you want to make sure you're trying to protect your company reputation, right? You're trying to keep this confidential as you're going through the process, okay? So that's what we're trying to do here. Another popular thing that you need to think about if you're trying to handle these cases on your own is limiting the scope. And now I say that because sometimes you'll get a letter from, let's just say, the Business Software Alliance, BSA, and it may say, we represent the following companies, you know, Minitab, Autodesk, Microsoft, Bentley Software, and you know, so you get this list of names, and they'll be saying, we need you to audit all these, and you're going, a lot of companies are going, I've never even heard of Parametric. What is that? What's Minitab? So, you know, so another common thing you may need to do is to try to limit the scope. That's something that you have to negotiate. And again, oftentimes you're going to be coming back here talking about the informant, what they have, what is that probable cause, what I call probable cause evidence, what do you have, how credible is it, did you vet this person or did you not vet this person? Okay, well, let's limit the scope. Let's limit the scope. A lot of times with BSAs, you know, at the end of the day, you're looking at Microsoft or Autodesk. Not to say exclusively, but lots of times, let's say, okay? So you try to limit your scope. At some point, if you're going through this process, you may say, we need to audit, we need to know where we stand, we want our business to be compliant, we need certain amount of software, let's check, let's do a diagnostic, let's see what we have, okay? So you can do that, you can audit, usually that's through a spreadsheet, usually you get your IT team involved, you may have a little team that you want to keep this kind of quiet because you really don't want your employees knowing, hey, you know, we're under investigation for software piracy. So you don't want necessarily people to know that. So you may build a small team, you may have board meetings on this to keep this small in a box, okay? So again, you're going to be looking at this stage at your exposure. Now, when you get these demand letters, bear in mind that they're usually threatening you with $150,000. Let me say that again, $150,000 for federal copyright infringement per infringed work. So again, if you have Microsoft and Adobe and over here Adobe and Autodesk, you know, one of each, you may be looking at $450,000 in liability plus attorney fees. So you want to take a close look at where you're at as far as your potential liability. Now, when we settle these cases, usually we're not anywhere near this $150,000. Usually we're looking at MSRP, what you can find this on the website for, and it's usually their MSRP, not your special discount that you may find somewhere. So it's MSRP times 3, 4, 5, however willful they believe this to be, and we'll talk about that in a second, and we've talked about that in other videos, I believe. So, but you want to assess your exposure and make a decision. Do you want to engage in the audit? Do you want to blow it off? Do you want to play chicken and challenge them to sue you? Realizing that the lawsuit process, as I have here in my last two steps, that can be expensive, that can be time consuming. They may not want to do all that, so you have to weigh this out. We have this down here, is the lawsuit, the cost of a lawsuit, and eventually prevailing and eventually collecting on a judgment if they're going to do that. So the BSA and the SIIA, they do want to negotiate these cases, and these are things that you sort of just build into here. So, but you want to decide, do you want to engage? These are voluntary. They will tell you these are voluntary. You do not have to do this. This is not law enforcement. This is not a search warrant. You know, this is not something where these publishers have the right to put you in jail for criminal copyright infringement or anything like that. Okay, so you have to deal carefully with them. And by the way, speaking of criminal copyright infringement, you have to be careful, because when you hit a certain threshold in the type and amount of infringement that you have, at some point, this moves from civil to also being potentially criminal. Okay, in other words, you could have a United States attorney wanting to prosecute. So you have to be very careful. And bear that in mind at this stage when you're deciding to pick up the phone and talk to somebody. You're much better off calling an intellectual property attorney first, so that you can evaluate and assess where you stand, what the risks may be. Okay, it's very important. So we're here, it's engage or don't engage. It's making that decision whether to voluntarily push forward or call it off. Okay, and so there's other techniques involved if you're pursuing one of these or the other. From there, usually we're talking about negotiation. This is where you're getting into the dollars and cents, the nitty-gritties, the settlement terms, okay? And they're trying to paint you out as willful, a pirate, you know. They're trying to paint you as a pirate, and they're trying to show that you should be paying these exorbitant amounts for willful copyright infringement. They may actually call you a criminal. We've had federal raids threatened. We've had threats to, we're going to go in and shut your company down. Okay, mostly, let's say in all cases that I've dealt with anyway, it's been a veiled threat and hasn't come true. But just bear in mind the types of conversations you may find yourself in if you decide to pick up the phone. Okay, so you have willful, that's what they're fighting for. We're usually pointing out that if there is infringement, it's due to this, that, the other. We've got lots of reasons. We're in the process of posting a nice blog on that, but lots of different reasons. It's human nature. There's lots of different reasons. Software gets installed without the receipts. You may have lost them. Somebody else may have installed it. You may have OEM software. You may have bought something at a garage sale that could have been in it. It's all so many different things. I'm not going to go into them all here. But this is the negotiation process, the back and forth. And, you know, so you're weighing in some of these in your discussions. You're looking at your informants. You're also weighing the costs of a federal copyright lawsuit, the likelihood that they'll prevail. So there's lots of different arguments that go in here. I can't share them all in this video. Some of that's frankly, our trade secret, being a leader in this field. From here, we go on to, once we can reach terms, part of that, these kind of go hand in hand right here, the negotiation and the settlement. But what a lot of people think is, you know, we've reached the terms, we're good to go, we've got the terms. But usually then you start getting, you know, 5, 10, 15 pages of settlement documents, legal jargon going back and forth, right? So now you have to read, understand, negotiate the settlement agreement. I've even had other attorneys that just say, well, I was handling this myself and I don't know if I'm I don't know if we're setting ourselves up for disaster here, and so then they'll retain our firm at this process. So bear that in mind. Like I said, we give low flat rate fees to make this predictable, affordable, to take this out of your hands so that you can go forward doing what you do best, making money what you do. Maybe you're a graphic designer, architect. You do what you do, we take care of this. But you have things like, often these are typical terms that they'll want to negotiate. You have future audit terms. They'll want to come back in at your cost and at your inconvenience. So these are things that we negotiate. They may want you to make certain admissions. Well, you know, we admit we had this. Be careful, we're admitting things here, right? Settlement's not even done and we're admitting things, so we have to be careful. They may have you implement a software code of ethics. They may want you to impose a new human resources requirement, giving a copy of this to all employees. So you got to bear in mind, these are terms that we fight for to get those out of there. To just get those out of there and fight and limit these to the best extent we can. So those are some things we do. If you're handling your own case, those are things you need to be considering. Payment plans are possible. Financing is even possible. We get links to, hey, if your client can't afford it, here's the bank that you. So we try to avoid that, you know, so forth and so on. And they may be asking for certain proof of deletion of software and purchasing of new software. So there can be a lot of different terms here. If you look at everything, all the potential issues, you know, you have to ask yourself, is it better just to forge on and do it myself and try to save that money, completely setting yourself up for some big potential pitfalls? Or should we just pick up the phone, call Attorney Steve, find him on softwareauditlawyers.com and get them engaged so that they can best protect your interests? I like option B, but I'm here sharing information with you if you're choosing option A, okay? So that's really about it. That's all I have for you today. I hope that's been helpful. If you need help with copyright infringement cases, whether you're a plaintiff, a defendant, a software company, a company facing an audit, if you have a copyright bully, somebody's bullying you around for $150,000 for a video, a picture, those kinds of things, give us a call. We've been doing this a long time. By the way, there's other firms that are popping up in this area. Make sure the firm you're hiring has it's at least litigated a copyright case in federal court. Make sure that that you can actually find them on the federal court PACER site and find that they're actually have experience dealing with a software company. Lots of little guys popping up, and a lot of people watch my blogs and try to find that great information, but there's no substitute for experience. We've helped many companies. We're here to help you. Okay? Thanks a lot. We appreciate you listening. Feel free to share this video on your social media networks. And don't forget to click wherever they put that roving red V. Click on that V for victory for future legal updates. Attorney Steve Vondran, thanks a lot. Have a great day.